Next, we're going to take Representative Places. He has a group of bills. Are you with us, Representative Place?
Yes, Madam Chair, just get my video getting cranked up. There we go.
Ah, there you are. So you have...
Sorry. Let me turn it back off.
We don't see you. If you want us to see you, you
Working
can...
on it.
Anyway, you have
Yep.
three bills before us, so I'm going to ask you to put them all in play. House Bill 5319 is an act relating to criminal procedure, search warrants, Electronic Information and Data Privacy Act. Requires law enforcement agencies to obtain search warrants for electronic information, data, location information, and other identifying information of subscribers and customers, except in specified circumstances. House Bill 5320 is an act relating to criminal procedure, search warrants, audio and videos of private property, warrant required. Requires law enforcement to obtain consent on a warrant before placing audio or video recorders on or near the private property of another. A violation of this act makes any evidence inadmissible in a court proceeding. And House Bill 5321 is an act relating to criminal procedure, indictments, informations, and complaints. It prohibits prosecutions for violations in this state if violation arises from the same facts or acts for which the defendant has been acquitted in another jurisdiction, unless there exists new evidence substantially warranting prosecution in the state. So if you would like to proceed on all three, because we have the same witnesses testifying on all of them. So proceed, Representative Place.
Thank you, Madam Chair. Let's see, I'll start off at the top, 5319. I'll speak in the legalese. It pretty much overturns the third-party doctrine established by the Supreme Court of the United States dealing with the Fourth Amendment against warrantless search and seizure. The Supreme Court said that if the data on your phone, if your emails or text messages, stuff like that, if you're sending that to a third party, your Google or Apple or something like that, they don't need a search warrant to get access to that information. Same thing applies to your location. If you were somewhere and they can just go ahead and just sweep up all the location data and know that you were there and just, for whatever reason, just sit there and track you down. There's a lot of violations of privacy. What this would require is that the law enforcement acquires search warrant. No difference than if they're going to search your home. So if they're going to search the stuff that you've put into a cloud or where you've been, they need a search warrant to also take care of that as well. Let's see, what else do we have? The 5320 also deals with the Fourth Amendment. Right now, there's another Supreme Court precedent known as the Open Fields Doctrine. They say that the Fourth Amendment, again, against search and seizure, does not apply to any areas outside of your curtilage. I think that's the second time we've heard that word tonight. I think Leader Filippi said earlier in the day, but the curtilage is generally the area directly, your house itself, the area directly around it, your front yard, your backyard. You've got a 100-acre piece of property, it doesn't apply to the rest of the property, just the area around. So if law enforcement wants to come on your property, put a camera up and observe you on your property, they're more than able to do so. So again, this is just, honestly, we can always say this, I don't think anybody denies that the Supreme Court has made mistakes in the past. And these are just all attempts to fix those mistakes, because the third bill I have is 5321, which deals with the Fifth Amendment, dealing with double jeopardy. We all know, you're not supposed to be tried for the same crime twice, but unfortunately the Supreme Court looks at it that the state and the federal government are two totally different sovereigns, so that it's not incorporated. It doesn't apply. So what this is saying, that if you as a Rhode Island resident are ever charged in federal court and you win your case and you're found not guilty on the facts, the state of Rhode Island can't come back and charge you for that exact same crime based on the same set of facts. The only way they can do it is if the facts change, so that new evidence is presented along those lines. But again, if you're found not guilty at the federal level based on the facts, this would prevent the state from coming after you. So there they are, Madam Chair. Thank you.
Thank you, Representative Place, and thank you for bundling those three together. So we have Randall Rose on the line. Hello, Randall, are you with us?
Yes.
Representative Place has put in play all three of his bills, House Bill 5319, 5320, and 5321. Would you like to testify as to all three?
Yes, I would. Thank you.
Okay, you may proceed.
Okay, thank you. So let me start with 5320. That's the bill about placing cameras and placing cameras to record things on your property. It's basically that this is a form of stalking. It's just like if somebody stood a little bit outside your property to watch what was going on. It would feel like an intrusion of privacy. Certainly, it's especially wrong if police start placing audio recorders or video recorders near your property to watch what's going on night and day without your knowledge. It's basically, even though they're not physically inside your property, in some cases it still feels like an invasion of your property of your privacy to be monitoring what's going on there night and day. And I understand that there are sometimes good law enforcement reasons for doing it. If they have good reasons to suspect there's a crime going on, it can be justified. And in those situations, they should just get a warrant. And that's what Representative Place's bill says. It says that if they want to monitor events taking place inside your property with these recorders, they should just go to a judge and get a warrant to make sure that they have good reason for doing it. If police are allowed to do it with no warrant, it means that they can do it to people who are completely innocent, who have no basis for suspicion, and that's just wrong. We do not want to live in a world where police can just monitor what you're doing night and day. I do have a slight change to suggest for the bill. As it's written, the bill only applies to placing audio and video recording devices. I think it should also apply to devices that don't have the ability to record, but simply transmit the audio or video elsewhere. But with that change, I'm in support of the bill. And I'll go on to the next one unless you want me to stop there.
Nope. Go to the next one, Randall.
Okay, thank you. The only other one I signed up to testify on was 5319, which is a very similar bill involving obtaining data from your cell phone or laptop or other device. And again, it says if the law enforcement has a good reason to be going through your data, going through the data you have entered on your device or stored through your device, then fine, they can do it, but they have to get a warrant first. There are many situations when it's worthwhile to go to a judge and get permission to get a warrant when you have a basis for suspicion. But if there's no basis for suspicion, and if we allow police to do it when there's no basis for suspicion, then that means that anyone can be targeted by having their information gathered. So this bill says that in most cases, you need a warrant. There are a number of sensible emergency exceptions in the bill where there's imminent risk of death or sexual abuse or kidnapping. There are a number of reasonable exceptions like that in the bill, but in most cases, police should get a warrant before doing this. And as Representative Place said, the Supreme Court has failed to recognize there's the privacy interest here. They say that if you enter information onto your cell phone, then that's information you've given away to the cell phone company, which is a third party, so it's no longer your own private information. That's a very old-fashioned Supreme Court view. Recent Supreme Court decisions cast considerable doubt on that. Justice Gorsuch has argued against it, and even in the original case that established the third-party doctrine, Justice Thurgood Marshall vigorously dissented, and instead this would have allowed the segregation-era police in Alabama to search through the NAACP's records. So it was a bad decision. It was criticized at the time. It's being changed, but since nowadays we have so much of our private information held by our cell phone companies or held on our laptops or in the cloud. Police should get a warrant before accessing our private information. So I'm in favor of the bill. Thank you.
Thank you, Randall. Are there any committee members who have any questions of this witness? Seeing none, that concludes the testimony on House Bill 5319, 5320, and 5321.